All right, hello everyone, and welcome to today's lecture where we will be continuing in whiteness as property. For the pages that you were supposed to read for today's lecture in whiteness as property, the article, make sure you check the course syllabus. If you're in Google Classroom, just check where the assignments are. You'll see the syllabus there. That will give you the page numbers. If you're on TikTok, check the playlist. You'll see where the course syllabus is at, and then you'll be able to go to those pages, and you'll also be able to access part 1 of this lecture, which you will need to do to understand what's happening in this lecture. So make sure you check out part 1 and make sure that you are doing the readings along with the lecture. So let's go ahead and get started. What is our roadmap for today? And I don't anticipate this lecture being that long. What we're going to do is we're going to start off with a review, looking at what we talked about in part 1 of understanding whiteness as property. Then we're going to talk about Plessy versus Ferguson. We're going to talk about Brown versus Board of Education, both the first and second portions of that case. Then we're going to look at revisiting Ozawa, and then we're going to look at the legacy of Brown versus Board of Education by way of a case study that takes place in Los Angeles. So let's go ahead and begin with our review. What is it that we did in part 1 of understanding whiteness as property? First of all, we defined out what property is. And in order to define out what property is, you have to remember that we're not just necessarily talking about real estate or a car, things like that. We were really looking at the philosophical development of what property meant and how that played out in law. And to do that, we looked at 3 different areas. We looked at the founding era of philosophy and talked through that. Then we looked at the traditional era and we looked at James Madison as an example. And then we talked about the modern era, which is now where we are at. And by looking at all of these areas together, what we understand property to be is that which is both tangible and intangible. And that it is something that both retains and accrues value and also affords rights or extends rights out. After we move through that and move through understanding what the definition of property is, then we looked at cases and instances in the United States wherein whiteness has been propertized. And that allowed us to understand that whiteness as property is not a theoretical assertion, that it is actually something that happens in law. After we came through that, what we were able to come to an understanding of is that whiteness as property is made viable or possible via the social contract. So again, if you did not catch part 1 of this lecture series, make sure you check it out so that way you are up on what's going on. Let's go ahead and move forward and let's get back to this Plessy case. Remember, we started our understanding of whiteness as property by talking about Homer Plessy and what took place in Louisiana. And something that you should recall is that his case comes about because he was arrested for violating the Louisiana Separate Car Act, which was passed in 1890. And as a result of being arrested, his case eventually makes its way up all the way to the Supreme Court. And what you also have to keep in mind here is that Homer Plessy is someone who is mixed race. Right? So there is that. So let's look at these things, this particular case, a little bit closer so that we understand the moves and dynamics that are happening here and how we come to this idea of whiteness as property via the work of Cheryl Harris. So Homer Plessy is before the Supreme Court. He is making his argument via his attorney. And what are some of the things that his attorney says? And I'm on page 1748 of the PDF if you are following along. Homer Plessy's attorney says this. He says, "How much would it be worth to a young man entering upon the practice of law to be regarded as a white man rather than a black one?" And of course, I'm adjusting the language for our contemporary time here. He goes on to say, 6/7 of the population are white. 19/20 of the property of the country is owned by white people. 19/900 of the business opportunities are in control of white people. Now pay attention to this line. His attorney says, and this is before the Supreme Court, his attorney says, quote, "Probably most white persons, if given a choice, would prefer death rather than life in the United States as a black person." He goes on to say, under these conditions, is it possible to conclude that the reputation of being white is not property? Indeed, is it not the most valuable sort of property? There's that value. Being the master key that unlocks the golden door of opportunity. So in the late 1800s, we have an attorney that is before the Supreme Court that is saying that whiteness is a type of property, that it extends protections, rights, and entitlements, and has a value to it, right? And remember, his client is what? Mixed race. All of this is important. So technically, with him being mixed race, should Homer Plessy be able to access those rights, those benefits, those protections, those entitlements, etc., by sitting in the whites only car, right? Here is what is key to understand in this case. The Supreme Court is trying to come to a determination of, did Homer Plessy suffer a harm by not being allowed to sit in the whites only car in Louisiana? And as they are evaluating this harm, pay attention to this, what is centered, what is used as the rationale, as the framing for understanding if a harm has taken place, is their definition and their understanding of whiteness, as opposed to Homer Plessy's experience and his denial of the Equal Protection Clause that is located in the 14th Amendment. Because remember, he is using the Equal Protection Clause to propel his case. Here is what the Supreme Court says on the next page. Okay, and this is a direct quote from the justices in their opinion. They say, if he being Homer Plessy, be a white man and assigned to a black coach, railroad car, he may have his action for damages against the company for being deprived of his so-called property. In other words, if he was a white man and got, placed within the railroad car where black folks were assigned to seat, then he has a claim here. So the court is doing two things. The court is implicitly acknowledging the rights, the entitlements, and the protections of whiteness in law. Catch it. At the same time, what they are also doing is they are rejecting Homer Plessy's claim because he's of mixed race and therefore he is not considered white. So what is very much in the forefront here is the one drop rule. Right? You can't miss this. Let's go on. What does the court also continue to say? They say, upon the other hand, if he be a black man and be so assigned, in other words, if he is a black man and assigned to the white area to sit down, he has been deprived of no property. He is not suffering a loss, since he is not what? Lawfully. Circle that word. Put some lines under it. Lawfully entitled to the reputation of being a white man. By this line, the Supreme Court affirmed rights that were extended to white persons by way of whiteness as property. And what they placed in law was two things primarily: that segregation was now legal, and that white persons had the right to assert a claim in court in the event that they were not extended their rights, their entitlements, and their protections via whiteness as a form of property that guaranteed them that right. Going back to the example that we used in the first lecture, that would be like you having a license and then a police officer pulling you over and saying, I see your license, but you still can't drive, so therefore I'm going to cite you or arrest you even though you have a license. Peep game. The Supreme Court acknowledges the rights, the protections, the entitlements in whiteness as a form of property. It says that it is so much so that segregation is legal because those rights are so tangible, so embedded, that white persons deserve their own area where those rights can be observed, practiced, and carried out. It is from this case that we get separate but equal. However, we all know that separate was not equal because the facilities that was going on in the white-only areas versus what was going on in the non-white areas, right? Because it wasn't just black folks in those areas. It was also Latino folks, right? It was also those of Asian heritage in those areas as well, right? But what comes about is that there is a type of protection that society begins to do of white life. And what begins to happen? Those rights, those protections start to become expectations, and those expectations become the foundation for what? Social norms. Such that when that socially constructed approach to society and preference for whiteness is challenged, and there are efforts to bring about equality, you get claims of what? Reverse racism. So making our way back to the Plessy case, what does the Supreme Court do? They deny the equal protection claim of Homer Plessy. And what is the court doing? They are hearkening back to the Dred Scott case of 1857, where the Chief Justice says that the black man has no rights to which white men are obligated to respect or to acknowledge or to recognize. Do y'all see what's happening here? Are you understanding what it means by what Cheryl Harris means by whiteness as property? That it is something that is protected. It is something that is jealously guarded. And by looking at this Plessy versus Ferguson case, we get a greater understanding of that. Now, what's interesting about this Plessy versus Ferguson case that we also must pay attention to that has significant implications for our present day time now is that the railway officials of this particular company assisted in Plessy's case, because even they disagreed with Louisiana's 1890 Separate Car Act. So here we see a corporation going to bat with Homer Plessy. And why are they going to bat with Homer Plessy? Because it disadvantaged them economically. Turn with me over to page 1747. Really bottom of page 1746. And it says that Plessy's arrest was arranged as part of a strategy that included the tacit cooperation of railway officials, many of whom were displeased with the separate car law. Why? Due to the increased expense of operation. In other words, this company will say, hey, this racism is costing us more money. We have to produce a separate white car. And it's not just that it's got to be another car on the railroad, but that car has to have certain amenities that is not present in the other cars, and it's costing us more money. Pay attention to this. Notice they are not going to bat for Homer Plessy himself. They're going to bat for their wallets. In other words, anti-segregation attitudes did not mean anti-racist attitudes. One more time. Anti-segregation attitudes did not mean anti-racist attitudes. So when corporations are doing DEI initiatives, this is historical. When they're doing DEI initiatives, when they're doing affirmative action initiatives, right? Just because those initiatives are there doesn't mean that they are anti-racist. It just means that they are doing what is economically convenient at the time. And how do we know this? Because corporations are now beginning to pull that back, because now they don't have to spend the extra money in that area, because there is an administration in place that has made it possible for them to retain their same profit margins without having to do that work. So pro-DEI attitudes does not mean anti-racist beliefs. Let's move forward. Let's talk about Brown versus Board of Education. So you have Brown versus Board Part 1 that takes place in 1954. That is the actual decision that says, okay, schools must desegregate. Brown versus Board Part 2 takes place in 1955, where they actually lay out the framework whereby which schools must desegregate. So, in revisiting this case that most of us are familiar with, you will know that the Dahl test is central in this, right? That leads to school integration. But the one thing that we need to know about this is that Brown versus Board of Education represented a radical departure from the historical arc of the United States. Because remember, we're dealing with separate but equal, but Brown versus Board of Education in 1954 breaks that up. It does an end to that. So over all of these years, think about this. We're not just talking about the 1700s. Really, stuff starts, coming together in the United States in the 1500s. So the 1500s all the way up to 1954, whiteness has been protected in law as a form of what? Property. Going back to what Charles Mills said about those who gather in the room. Y'all remember that moment, right, that we talked about in that lecture. So you have to keep these weeks and these lectures with you. That those who were gathered in the room were able to make a social contract by way of a racial contract, because they had already agreed on what it was going to be before they already put the social contract into play. And based upon that racial contract, they formed the nation to be in service to them, not to people that did not look like them. So when we get to Brown versus Board of Education in 1954, and the Warren Court breaks up this whiteness is property, the nation is thrown into a little tizzy because this has been standard of practice. In other words, what am I saying? That Brown versus Board of Education, the Voting Rights Act, the Civil Rights Act, gender equity, pay equity, the acknowledgement of queer rights and queer marriage, all of these things, affirmative action, DEI, all of these things that come through the court, all of these civil rights cases, those cases are actually radical departures from the historical arc of the United States. Because the United States has always been in service of a very specific demographic. In the current moment that we are in right now, the whole effort, the whole point is to push the United States back into its historical white conservative arc. Because there are a number of people that have been upset since 1954 because they perceive their property rights vis-a-vis whiteness to have been disrupted, that have been in place since the founding of the nation. Do you all see what's happening here? But what are the critiques around Brown versus Board of Education? Let's take a look at this. In 1954, when the case decision actually comes down that schools must desegregate, what is left on the table by the court are the material differences in place that were without remedy. In other words, they said that schools must desegregate, but they said nothing about the material resources, that schools in black communities and communities of color did not have the same resources, did not have the same buildings that were built with the same integrity. They did nothing about the material resources. All they said was, you must desegregate. And what did that do? That set the foundation of desegregation on an uneven and inequitable foundation, thereby reinforcing the rights, protections, and entitlements assured via whiteness as property in place, and secured those same rights to those persons who possessed whiteness as a form of property. In other words, even Brown versus Board of Education, as a progressive case, still left in place the rights, the protections, the benefits that were still affiliated with whiteness as property. Why? Because they did nothing about the material inequality that was taking place in black and brown communities or in black and brown schools. All they said was, you have to desegregate. And so even, here we go, think back to the social contract. So even in this moment of Brown versus Board of Education, this moment that Thurgood Marshall is arguing before the Supreme Court, even this civil rights moment is established on what? uneven ground. And the Supreme Court allows inequality to be seen as what? Equality. And this is where integration begins to run into issues. That is the critique of the 1954 Brown versus Board of Education decision and when it came down. Let's look at Brown 2 when they actually lay out the framework whereby which the ruling that they said in Brown versus Board Part 1 must be done, right? They said, okay, you got to desegregate. Now we're going to come back in this opinion and we're going to tell you how you're going to do it, right? And this is what they say. They say you must do it with all deliberate speed. With all deliberate speed. But what is the problem here? The problem here is the framework by which desegregation was to take place is a problem. Because the decision making, and that's with all deliberate speed, right? The decision making was given to the states in order to desegregate, again, with all deliberate speed as opposed to what? Immediately. Immediately. By saying with all deliberate speed, this allowed states and institutions to take their time in desegregating. And accordingly, time was permitted to not only file lawsuits and different claims of injury against Brown versus Board, right? But it also permitted to shape the means of desegregation so that white persons would not experience an interruption in the rights afforded to them via whiteness as property as a form of property itself, which extended to them both the social and political entitlements they freely enjoyed. So in both iterations of Brown versus Board of Education, we still see that whiteness as property is acknowledged. In the first instance, there's nothing done with the material inequality that still exists, by the way, right? In the second instance, states and institutions are given the order to do so with all deliberate speed, which allowed them to take their time and determine the speed at which they would move, rather than immediately, which allowed for white folk, right, to figure out how they wanted to engage this moment, what they wanted to do with their kids. Private schools, charter schools, right? What were they going to do? File claims? It gave them time to figure that out. So, knowing this, take this into consideration, that if the purpose of segregation was to subordinate and place at a disadvantage black people, as well as people of color, then desegregation technically should have done the opposite. However, by not addressing the material differences of inequality, that inequality, stratification, and discrimination continued to be in place even as desegregation took place across the nation. So then the rights, protections, entitlement, and material benefits in whiteness as a form of property were made de facto as opposed to de jure. Remember those terms, right, from our first lecture. Because de jure was the Plessy case. The Brown versus Board case allows these type of material benefits and entitlements in whiteness to become de facto by social norm. Remember that as law disallows something, tells you what you cannot do, it is also saying what you can do. And in that space, whiteness is acknowledged as a form of property, wherein rights, benefits, entitlements, and protections are acknowledged. I cannot drive this point home enough because we look at Brown versus Board of Education is doing this amazing work. But what we have to understand is that in this moment of desegregation, that material differences were left in place without remedy. There was no adjustment of the distribution of funds that were required by the court. They just said desegregate. And by doing that, they allowed for inequality in an uneven foundation in the moment of desegregation to take place. And therefore, inequality was seen as equal even in the Brown versus Board of Education moment. Let's move on and let's revisit Ozawa. And we talked about Ozawa's case a little bit in the previous lecture. Because what begins to happen now by way of desegregation is that there starts to be these claims made toward whiteness, because whiteness is understood as a form of property, even if in the de facto sense. Okay? So, as a way, by way of reminder, remember that Ozawa is of Japanese heritage, that he lives in Hawaii, he attended Berkeley, and what he's trying to do is move for naturalization, and he's making a claim for citizenship via whiteness, and he's leaning on the Naturalization Act of 1790. And what you see on the screen here is the argument that comes from the Supreme Court syllabus, where they produce all of their cases, and this is from the October term of 1922. Right? And it says this, and I'm going to read this again because this point needs to be driven home for us to get to our case study that we're about to get to. Ozawa argues this before the court. He says, at the time the original law was passed, which provided for the admission of aliens being free white persons, there can be no question, but white was used in counter-distinction from black, and free white persons included all who were not black. In other words, Ozawa understood himself to be white. And he said, I deserve to be a citizen of the United States because I am not black. That was his claim before the Supreme Court. So his claim to citizenship is made vis-a-vis an anti-black claim. And what he also inherently understands is that black people are not citizens in the United States even in 1922. He then goes on to say the latter were chiefly slaves regarded as an inferior race, and that is not him. And the reason why I'm pointing to this, even though 1922 is before Brown versus Board of Education, is because this particular anti-black attitude comes to inform a lot of things that begin to take place. Let's look at a case study that comes out of Los Angeles, dealing with the legacy of Brown versus Board of Education and understanding, making claims on the state. Okay? In Los Angeles, there was an organization called Bus Stop. Bus Stop originated in the San Fernando Valley. If you are familiar with Los Angeles, you know exactly where that is. And Bus Stop comes up in the 70s. So we are how many years past 1954? This is the problem with all deliberate speed. So even in a liberal state like California, you have parents who are saying, you're not going to school with my kid, right? And my kid is not coming to your community. Because they understood their rights vis-a-vis whiteness as property. And Bus Stop is started by conservative white housewives who are Jewish. And they start this organization to say, our kids are not leaving the valley, your kids are not leaving where they're at, and they're certainly not going to cross over. And eventually, of course, mandatory busing takes place. And by the way, the people who you are looking at is Bobby Fiedler. And you're also looking at Roberta, and I can't recall her last name right now, Winthrop, Roberta Winthrop. Roberta is sitting on the LAUSD board. Bobby Fiedler comes to serve in the House of Representatives. Both of them were anti-busing champions. And Bus Stop was so potent in Los Angeles politics that whenever something happened, as you can see by this article here, it says Bus Stop president to quit. Whenever something happened with Bus Stop and they replaced the leader or whatever have you, that made the news right away. Because those who were even in Los Angeles all these years after Brown versus Board of Education understood their rights vis-a-vis whiteness. So we see other ethnic groups start to make a claim on whiteness and that they should be included as such. They even threw parties to celebrate the last day of mandatory busing, as you can see this with this particular flyer that I've placed here on the slide. Because one thing that all of these groups were familiar with and aware of was that they were not black and they did not want to be treated as black. They didn't want to be marginalized like black folk. So their efforts was to claim that property of whiteness and to get as close in proximity as possible. Copy and paste to 2025. When there are folks of different ethnicities, races, etc., that are at university campuses making claims saying you're admitting too many black students, we aren't getting in, but we deserve to get in because we are not them. Only to file the case and end up like Azawa when the Supreme Court told him, you're correct, you're not black, but you're not white either, so you still don't get citizenship. And all of these years later, that same thing is happening. Okay, you're right, you're not black, but that doesn't mean that you deserve admission to Harvard. It's historical. It's historical. And by understanding this, we come to understand that whiteness is a type of property that is codified in law, even in 2025, that accrues value, that extends rights, and that allows for a certain protections and entitlements. And the one question we've got to ask ourselves as a world that is majority non-white is, why are we all running toward a Western philosophical, harmful technological development called race, as opposed to saying, let's redo this? Everyone, well, not everyone, a good number of people are running to be included in, as opposed to saying, but I'm a part of the majority and finding significance in themselves. And the questions we've got to ask is, why? That's it for this lecture. I'll see you in the next one. Peace.